All right, we'll call People v. Joshua Coors. It's filed 26-7127H.
Good afternoon again, Your Honor.
All right, and we've got Ms. Goodrich, prosecuting attorney, present as well. This is sentencing on operating while intoxicated with an occupant under 16 years of age, as is with a second offense notice that makes it a 5-year statutory maximum. But when I have received some letters of support this afternoon that I did have an opportunity to review. All right, Mr. Kuski, anything you want to say in the plans?
Thank you, Your Honor. I would, I guess, indicate that we have had discussions in chambers that there was a binding sentence agreement in which Mr. Coors was, the prosecutor offered him a county cap. Your Honor's indicated that he's not going to follow that at this time. After speaking with my client, he is prepared to move forward with the sentencing, understanding that he's going to be held within the guideline range, maybe the top end of those. So with that being said, Josh was certainly demonstrated to me that he's learned a lot from this. I know he's got quite a history. He's been incarcerated and he's been in prison a few different times. I think Your Honor's put him there once. And this matter didn't happen that shortly after he was discharged from parole last time he was on. But he's been attending AA regularly while he's been in that jail. He's been going to service. He's been counseling with the pastor. He shows to me a lot of remorse. He loves his daughter dearly, who was in the vehicle at this time. He understands the gravity of the decision that he made and that he put her certainly at risk. And he, I believe, beats himself up every time I do talk to him about that. He wants to be a father. He wants to be a father to his daughter. And speaking with his daughter, he understands, and she's, kids aren't ignorant to these things. Kids understand these things. And I think she's shown a real ability to, and talking to him, that says, hey, you put yourself in this situation, you put me in this situation, that we're not going to be able to see each other for a while. And that really hurts. And I think Mr. Coors has shown adequate remorse for that. He's really, I think, going to turn over a new leaf. And I just pray that he doesn't continue this conduct. I'm confident that he won't in our discussions. And I'd ask the court to, again, stay within the guidelines. Maybe 20 to 18 months would be appropriate. Obviously, we understand that Your Honor's not going to keep him here in county. So, thank you.
Thank you, Mr. Kuski. Mr. Coors, you don't have to make a statement today, but you're welcome to. Is there anything you want to tell me or no?
Yes, sir.
Okay, go ahead and stand up.
I would like to apologize for you and my daughter. I know that I have a repeated history through tough cards, and I literally tried almost everything I could to almost manipulate myself into thinking that I could do it and figuring out ways to be able to do it. And every time I do, I get in more and more trouble. I never thought, because of the trouble that I've either been in or because of this or anything, that my daughter would ever tell me that she didn't want to talk to me. Sorry.
It's okay, take your time.
I was doing better since I got out. Actually, now I'm in prison. I got out and I was doing better than I had probably close to 15 years. Financially, being there, just a lot of stuff. And I know that one choice that I made altered the whole course of everything that I'm doing. And I know that it's very serious. I know that I could have potentially harmed a lot of people, which I don't want to do. I'm really going to take this time to, regardless of what happens, to get an order out of this. And I don't want to be released. My daughter will be late. And should be 8 on the 20th of this month, and again, I'll be there. So I don't drink. I would probably never be in trouble. So if I fight it's hard to not do it as much as I want to do it, I would apologize. It will not happen again. I just want to make things right with everybody.
Okay, thanks, sir. Ms. Goodrich, any recommendations from the people?
Thank you, Your Honor. This incident occurred on Tuesday, September 29th, around 3 p.m. Call-in came that Mr. Kors appeared intoxicated and falling asleep. When pulled over, he was honest that he had taken a shot around 10 a.m. that morning. A bottle of Fireball was found in his vehicle that was 75% empty. And his lab results were 0.15. Mr. Kors is 33 years old with 5 felonies and 7 misdemeanors. He's been to jail 6 times, prison 2 times. He's been on probation 6 times. We did, upon entry of plea, have a sentence agreement to a county jail cap. The court fairly warned us that the court may not follow that sentence agreement. There has been no misconduct by Mr. Kors since the time of plea, so I would still ask the court to follow the plea agreement. Thank you.
Thank you. Mr. Kors, if you please stand for the court sentence. Mr. Kors, you're convicted for operating while intoxicated with your minor daughter in the car. You have a prior conviction for an OWI offense. That's what makes it a felony here. And although I didn't score OB9 because we didn't have sufficient proof of precisely who you put in danger, your own statement acknowledges that there were certainly people that you placed in danger, and you seem to show an appropriate remorse for that. Some of your notable history here, in 2016, it looks like was your first trip to prison when probation was revoked in Emmett County, got an 18-month sentence. In 2018, another prison sentence of 24 months for an attempted assault out of Emmett. You were paroled in 2020. Then while on parole in 2021, committed a drunk driving and a domestic violence felony. That's the case for which I had sentenced you to prison for 23 months to 5 years. You were paroled in March of 2024, successfully discharged in June of 2025, but then less than 4 months later committing this offense. You've been on probation 6 times in the past, every single one of them unsuccessful, and had a parole violation to boot. The last 10 years, you've hardly had any period of time where you've been free and not been committing crimes. You seem today that you say that you're kind of tired of that. I hope you are. You know, you're 33 years of age now. So you're kind of at the tipping point, Mr. Kors. So I'll just tell you, in 25 plus years of just being involved in the criminal justice system in various capacities, I'll tell you, for some reason, plenty of guys in their 20s, not plenty, but there's a percentage of guys in their 20s that cause problems and are in and out of jail or prison. Some of those folks that are in and out of prison when they're in their 20s grow up and change, and they stop going to prison. Some of them, that was just the first part of their life on the installment plan. You're now 33 and going back for now your 6th felony. You're at that fork in the road. This could be your last trip, and I hope it is. If you mean half the things you say today, then get out and get yourself involved in AA and get serious about kicking the alcohol. And then you could be one of those people that we can say, gee, remember when Mr. Kors used to go in and out of jail and prison? Well, gee, he hasn't been in trouble in 10 years. There are people like that in this community. Many of us in this room know who those folks are. We're glad when that happens. But there's also a whole bunch of other people, we can give you a list of names, that they just keep going back and keep going back and keep going back. I have no idea which one of them you are, but we're going to find out together, aren't we? I think given that history, I can't abide the county jail cap. So I think I will, it would be my intended sentence that I think given the risk of harm to the community and the history that I have outlined, would be my intended sentence to impose $68 in state cost, $130 in the crime victims assessment, $350 in court costs, $300 OUIL reimbursement, and a $500 fine, and commit you, Mr. Kors, to the Michigan Department of Corrections for not less than 23 months, nor more than 5 years, with credit for 165 days previously served. That is a sentence that does not follow a sentence agreement that you had reached. So you do have an opportunity to decide whether you wish to accept that sentence or withdraw your plea and go to trial with the habitual notice. And I know that we had some discussions before court where your attorney made you aware of that possibility. But now that it's a reality, if you want a minute to review that with your attorney, certainly do that. Do you know right now what you wish to do, Mr. Coors?
Yes, sir.
You don't want to talk to Mr. Kupiski anymore about it? And what would you like to do, Mr. Coors?
I'll do the 23 months.
All right, so that'll be the sentence imposed by the court. You can file an application to appeal to the Court of Appeals if you wish. If you want a lawyer appointed, you have to make that request within 6 months. We're going to hand you a piece of paper explaining that appeal process. Ask you to initial one copy for us, so we have a record to give it to you. The other one is for you to fill out if you want to take an appeal. Do you have any questions for me, Mr. Coors? Okay, good luck to you. Does that conclude your matters, Mr. Kupiski?
It does, Your Honor, and thank you.
Okay, you're good.
The rest of your day.